It's a device by which you can appoint somebody else to manage your affairs if you are unable to do it for yourself, or just to help you manage your affairs if you can only manage them to an extent yourself. Until 2007 you could only make what was called an enduring power of attorney, and anybody who did, those are still valid. You just can't make a new one of those anymore. Those dealt only with money and property. It wasn't possible to make a power of attorney to deal with your medical decisions and welfare, where you should live, for example, if you needed to go into a nursing home. So there was in 2007, two sorts of powers of attorney were set up. They're both called lasting powers, but one's a lasting power for your property and affairs, so rather like the old EPA, enduring power. And the other one is a lasting power for health and welfare. And the beauty of them is that you can appoint the person or people that you would choose to manage your affairs if you can't do it anymore, rather than, you know, if disaster strikes, let's say you had a stroke, can't manage your affairs, maybe only for a few weeks, but during that period somebody has got to keep the show on the road. And the alternative to you having an attorney is that somebody will apply to the court for a deputy to be appointed. That's what used to be called a receiver. That might be a member of the family, it might be a family solicitor, it could be a panel deputy. There are 60 of those around the UK, or England and Wales I should say correctly, of whom I'm one. The nice thing about a power of attorney is that you can choose for yourself, and it can be a member of the family, professional, combination of those if you feel that there are issues that a member of the family might need a hand with. And the attorneys, the way you make a power of attorney is that you fill in a form, basically. You can download them from the intranet if you want to. You can get them from the government site, the court's site. People do get in a tangle with them. There's quite a lot of bureaucracy attached to it, and you do need to make sure that you've got every I dotted and every T crossed in exactly the right place. You have to pay a court fee of £130 for registering power once you've made it at the Office of the Public Guardian, who then keep a light hand eye on things to make sure that nobody's doing what they oughtn't. And once the power is registered, the attorneys can then act, provided that the person who's given them that power is happy for them to make the decisions and can't make the decisions themselves. So to the extent that a person can make their own decision, they must be allowed to do that. You can just confer with them. If they really can't make the decision, then it's up to the attorney to make a decision in their best interests. Quite often people will appoint different attorneys for their property and affairs. Ideally you want somebody with a good financial head on their shoulders, from the people who might make the decisions about which nursing home they would go into, for example. It's more likely to be a close member of the family for that. Or should you be revived? If you're in a coma with no prospect of a quality of life after being revived, is that what you want? And who's going to tell the doctor what you want? And that would go into your health and welfare power. So it can be pretty extreme in what it does, but you can control how much power you give your attorneys within the document as to what decisions you'd like them to make, whether you want one or more people to make a decision, or whether you're happy just for one to do it. You can also appoint a backup attorney, so if you appoint somebody who then dies or goes off the rails or disappears abroad or whatever, you can have a backup attorney come in and take over. So they're good and flexible. I mean, in my view, you know, I think everybody should have one. People will say, oh, but I'm not old enough. But, you know, road accidents happen, sadly. Illness happens, sadly. And, you know, just because you're 20 doesn't mean to say it's not going to happen to you. Just because you're not wealthy doesn't mean to say that you don't have affairs that need managing. I've got a young lady, very young lady, who had a difficult time at birth. She's on benefits, she can't manage them, so I get to do that, to give her a hand with how to manage things and where she's, you know, to help her with where she's going to live and so on. So it's a good flexible system.
I'm Chris Ann Hall. I'm a constitutional attorney, author, educator, and talk show host. Let's talk about Oregon. Because it's not about the Hammonds. It's not about the Bundys. And it's time to take back the narrative. It's time to stop being directed and led by the media. It is time to stop being directed and led by the federal government's whims. It's time to know the facts. This is not about the Hammonds. This is not about the Bundys. This is about a federal government that is operating outside the supreme law of the land. The people are not acting lawlessly. It is the federal government that's acting lawlessly. The federal government has no authority to own any land outside Article 1, Section 8, Clause 17. Article 1, Section 8, Clause 17 says that the federal government's only authority to own land is 10 square miles for Washington, D.C., and the amount of land necessary to operate forts and ports at the permission of the states. So if the states don't want the forts and ports anymore, they have the authority to withdraw the permission. The only other section that someone could claim is Article 4, Section 3, Clause 2, that deals with territories and then further expounds on the application of the ownership of land that we talked about in Article 1, Section 8, Clause 17. Let's be very clear about this territories thing. Go read the Constitution. Territory is capitalized. This is a proper noun with a specific meaning, and the federal government owns no territory within the continental U.S. Territory is not even land that the government owns. Territory is land that the government holds in trust for the states. Once a state petitions to become a state and a member of the Union, that is no longer a territory, and the federal government has no authority over it. You see, once a state petitions and becomes a member of the Union as a state, it is an independent, free, and sovereign government. It's called the Equal Footing Doctrine, and even the Supreme Court of the United States upholds this doctrine. It says that every state that enters the Union enters on the same footing as the first 13. Go read the Declaration of Independence. You'll see what that footing is. Independent, free, and sovereign. You cannot be a territory and be sovereign. You cannot be a state and still be a territory. The federal government has no lawful control over any land in the states outside forts and ports and 10 square miles for Washington, D.C. Show me in the Constitution the authority for the Bureau of Land Management. I challenge you to show me, because you cannot. There is no authority for the federal government to dictate to the states or the people how they operate their land. Do not recite to me executive order. There is no phone or pen big enough to alter the Constitution. Do not cite to me congressional act. Congress cannot pass laws to alter the Constitution outside Article 5 amendment process. Article 6, Section 2, Clause 2 says that no law made by Congress contrary to the Constitution is valid. Alexander Hamilton said the same thing in Federalist Papers 33. No law outside the Constitution is a valid law at all. The Bureau of Land Management, the federal government controlling our land, is a law that is lawless. It is outside the Constitution. Do not tell me the Supreme Court said this or that, because the Supreme Court does not have the constitutional authority to expand the power of the federal government or create new powers. That is not the role of the Supreme Court. They don't even have the authority to be the ultimate arbiters of the Constitution. James Madison, the father of the Constitution, tells us in 1798, as he's arguing before the ratification of the Constitution, hey, the Supreme Court of the United States is not above the states. The Supreme Court of the United States cannot make law. The Supreme Court of the United States is not the ultimate arbiter of the Constitution. James Madison so very clearly explains that the ultimate arbiters of the Constitution are the states themselves. They are the creators of the contract. They are the drafters of the contract. They are the people, the ones who actually ratified the contract creating the federal government. The states are the creators of the federal government. They are the controllers of the federal government. It is time for us to understand the proper role and function of our government. Do not tell me Marbury versus Madison. That is circular logic. The Supreme Court cannot create an opinion that expands its own power. When the Supreme Court is the ultimate arbiter of its own power and its own authority, that is not a constitutional republic created by the people. That is an oligarchy where the power rests within the government itself. James Madison said, when the government controls the property of the people, that is not a just government. We need to realize that this is a constitutional republic. Government instituted among men, deriving its just power from the consent of the governed. If the federal government is not defined by the Constitution, why do we even have one? If the federal government is not limited in its power by the Constitution, then what is the limit of the federal government's power? If the federal government can dictate to the people and to the states how and when they can use their land, you are not a freeman. Freemen have control over their property. And when government dictates how you operate your property, the only thing missing in servitude are the physical chains. This is not about the Bundys. This is not about the Hammonds. This is about maintaining the integrity of the Constitution. This is about defending the constitutional republic. This is about making a defined and limited federal government that is under the power of the people in the states. So it's up to us to decide. Do we get led by the nose of the media narrative? Do we get controlled by the oligarchical power of the federal government? Or do we declare ourselves freemen? As our Constitution says, government instituted among men, deriving their just power from the consent of the governed. It is time to know the facts. It is time to stand for the truth. It is not about a person. It is not about people. It is about liberty. It is about power of the people, and it is about a limited and defined government. So I ask you today, what do you want? Do you want a constitutional republic where the people control the government, where the states are independent and sovereign? Or do you want a totalitarian oligarchy where a federal government decides what power it can have and it can own and how it can use that power with a pen and a phone or a law? Do we want an unlimited federal government? Or do we want to stand for what's right? Do we want to stand for what's true? I don't care what your politicians say. I don't care what your favorite presidential candidate says. The Constitution is the foundation of America. And if the federal government can set that aside, there is no limit on it at all. It's time, America. It is time to defend the republic. And it is time to put the federal government back in its limited and defined box. That will only happen when the people know the truth. Time to make that decision. If the people wish to be ignorant and free, wish for what never was, and what never will be. Understand, we are the holders of the power. We are the owners of our property. And when a government dictates property, we are nothing. We are nothing but tributary slaves.